client will do, that you first tell the expert that I want a 100 crore claim. That is the worst mistake that somebody does. That is one. Two is always try and get the tribunal to appoint an expert to get into the aspects of delay, quantum, etc., etc. So that's helpful, because then the concept of neutrality or impartiality comes in. Because when I lead an expert evidence and the other side leads an expert evidence, we will obviously cross-examine and try to break the expert's testimony. And that is again the process. It's like a fact witness. You bring in a fact witness, try to break his testimony and try to prove your own case. That entails loss of time, loss of money. Experts are very expensive. And ultimately the award, then again, it is to the same, you've gone back to the same place where you started. But if the tribunal, if the parties actually want an expert and a proper analysis of the claims and the counterclaims, which we are now seeing a small shift from days when parties used to just throw counterclaims at each other just because somebody has raised a claim of 10 crores, throw a claim of 20 crores just to counterbalance it. So I think that concept is also going away with the advent of the concept of experts being appointed by the tribunal. So I think the answer to your question is that if I am suggesting to my client about experts, I would say try and get it appointed by the tribunal itself.
Thanks for that. And just a follow-up question that, how typically damages are determined in a particular award? Let's say, for example, when you typically go to courts, you have to kind of, give a lot of evidence with respect to direct damages, a lot of cost, expenses which you have occurred. What about this thing in an arbitration, and what is the role of an expert over there?
So, Love, thank you for the follow-up. Firstly, there are few formulas that are applied. There is an Emden formula. There are various other formulas that experts use to apply to delays that have taken place. It is no one's case that if actually a matter has, a contract was going to take 1 year and has taken 3 years, 2 years have actually gone by. The machinery the contractor has taken there, the manpower is staying at the site. So the idling cost is there, the actual cost of idling is there. Now how damages are seen is that the expert appoints a formula that from day 1 to day 365, this was the expense per day, and now the manpower and machinery is lying vacant. Can it be the same? Because it is not working. Suppose we have all seen the times of COVID where some projects were halted. Can we say that the machine was working and was the manpower working? The answer is no. But should the contractor not be compensated for the time that has gone into it, or the ownership cost that has gone into it? Every machine today, you see, Love, you are more aware. Big machines require a mechanism, requires maintenance, requires keep up, etc., etc. All that cost has to be calculated, and the damages expert gets into all of it. They take the universal formula and try to match it to the best possible extent in terms of your project. So I think that is how they calculate.
Sure, but specifically the Contract Act per se does not allow consequential damages, like you just mentioned about the timings and the cost and the loss of profit. Still, that would be a part of the determination in damages, or it will be as good as we are going in a court?
See, I think the arbitrator has to apply a very neutral formula to it, and as Arbitration Act provides for a mechanism where you can actually appoint the way the breaches, etc., have to be calculated. So first the liability has to be established, and then it comes to quantum and damages. Whether damages have to be established in terms of the Contract Act or not is something within the domain of the arbitrator.
And just to add to the point what he has mentioned while he talked about the application of the methodologies, I would say. So here the role of financial experts comes into the play. The experts from the field of economics, finance, and accounting, they plays a very vital role in terms of applying the various methodologies on the basis of documentations that the parties have. And few of the procedures and few of the practices what I have seen across industries, that loss of profit method also can be applied, wherein they would evaluate the profit what claimant would have had made if.
I think there's a problem with the teams because of the debt.
Yeah, sorry.
No, please.
So loss of profit method, wherein wherein they will evaluate the profit what the claimant would have had made had there not been a breach. So that method can be adopted, and then at the same time a discounted cash flow method can also be evaluated and considered to consider the current position of future loss, whatever the claimant will occur in future. And that the independent expertise with the help of their objectivity and the analysis will add value to the arbitrators in taking the informed decision on the basis of factual data with the statistical modeling that definitely helps the arbitrator to decide upon a subject matter.
Sure. So one question to Namit. I'm sure you might have seen a lot of damages determination in an arbitration. And just to follow up Avnish and Gohar, KPMGs and ENYs and PwCs and all the big 6 or 4 of the world, I think many a times, they give you a different valuation, and one person's valuation would be something else, somebody else would be something else. And many a times this valuation is dependent upon the relationship between the parties.
Correct.
Right? So, as Gohar rightly said कि मुझे 100 crore का claim चाहिए, आप मुझे बना के दो. So, I completely understand that it can be reasonable, but there's a lot of difference in the valuation. So, as an arbitrator, in case if you have acted as an arbitrator, or in case if you are an arbitrator typically appointed by a client, and you are representing to the client, how do you really come up to a conclusion that this is fair?
So, good question. Thanks, Love. I think one as a lawyer needs to stand away from the client, reasonably assess as to what is the evidence which the client has actually handed over to you in order to demonstrate that claim. And that's why, and I started with that the concept of being able to prove each and every penny which you claim is becoming realistic. People are realizing that the law is shifting towards being in a position to lead evidence, to claim whatever you seek to recover as loss. And that is where the role of a lawyer becomes critical, for him to step away from what the client is wanting to do, see what evidence he is handing over to you in order to demonstrate his loss, and then try and restrict him to and counsel him to and convince him that this is the only evidence which you have been able to procure and hand over to me, and this is the realistic amount which the court will be inclined to grant in your favor if you are to succeed. So therefore, there is no point in seeking to recover more than what you can demonstrate. And there's a recent judgment of Justice Kohli as a sitting Supreme Court judge that merely by averring a particular fact, you will not be able to demonstrate it. And even 104 of the Sakshi Adhiniyam, which was earlier the Indian Evidence Act, supports that fact that a person is required to demonstrate whatever he asserts before the court. So that's how your role as a lawyer becomes very critical in able to counsel your client that in the absence of evidence, you will be unable to succeed in a claim.
Thank you. Avnish, as you are an in-house counsel with Kirloskars in Pune, when you have to typically tell your organization institutional arbitration versus ad hoc, there are a lot of institutional, like you have MCI, ICC, and so on, and you have Indian arbitration institution as well, and the ad hoc arbitration, it would be done by some senior counsel or retired judge. So what, as a legal counsel, would you suggest them, and what measures you will take to ensure that this is cost effective?
No, thanks, Love. This is a really important question. Being an in-house counsel, we have to deal with these situations as and when it comes. So, as rightly pointed out by you, if the item size of the contract under dispute, or if we are entering into a contract with foreign parties, then we tend to prefer a neutral jurisdiction wherein the international institutions comes into play, because they have standard set of norms, and the best part is there they acquire, I would say, the decision making power from both the parties. Those are set norms. Of course, they are expensive, but the precedences are there. So we tend to get into the international arbitration when if the opportunity given for local players, we tend to evaluate the exposure, and on the basis of that we determine that whether an ad hoc arbitrator, bench of arbitrator having 3 or 5, or one single arbitrator could serve the purpose. So on a case to case basis we tend to evaluate, but with overseas parties and having big ticket agreements, we tend to prefer a neutral place for jurisdiction and having the arbitration with a renowned institutional partner.
Okay. So you're preferring institution over ad hoc. Gauhar and Namit, your take on institutional versus ad hoc?
I think the shift these days is towards institutional arbitration. There are 2-3 reasons to it. One is that you get the necessary administrative support that is required to conduct an arbitration. Second is, yes, the arbitrator is only then focusing on what he's supposed to do, that is decide, judge between the parties. So I think the rest of the job is taken care of by somebody else. Third is, what I have seen in my practical experience is that it gives some sort of systematic approach towards things. Because today if I have to ask for an adjournment, I'm just telling you while we are discussing, and I have gotten a request for adjournment because it's an ad hoc arbitration. They've just sent an email, matter is tomorrow. They said, we can't come tomorrow, let's have it some other day. But if this is SIAC, or if this is ICC, or any other institution, we get jitters these days to send a genuine request for adjournments. So I think that is very important. The general mentality of us litigators in India is that no difficulty, we'll get it pushed. But in institutional arbitration, there are costs involved.